Hi, everyone. We're going to try and do a little bit of an exercise. So I'm going to share what's called a Mentimeter. If you can see my screen. Is that a yes? Okay, good. So we're just going to do a little word cloud. If people have access to a smartphone or a computer, then you can join either by your phone or go onto your web browser and go to www.menti.com and enter the code that you can see on the screen. Once you've entered, you can press the heart, and when I see that I have some hearts, then you're officially into the Mentimeter. So we're gonna see how many people we can get on. And don't worry, if you're not able to access it, you can always share your thoughts and ideas directly in the chat. But this is just a way of getting kind of some ideas up whilst we can all see it live and interactively. So let's see, I have 4 people. I'm going to give it another minute to see. So remember, when you come onto the screen, just press the heart, even though it's not obvious necessarily. Perfect. Okay, we have quite a few people. Okay, let's try it out. Again, if you're not able to access, you can add your ideas and your thoughts into the chat directly. Oh, we suddenly got way more people. Okay, I'm just giving it one more second. Okay, so now comes the first question. What do you think about when we say customary law? You're only able to add 3 thoughts or ideas. But if you have more, you can feel free to add that later on in the workshop today. So when you add your things, press send or next, and then they should come up automatically on the screen for everyone to see. There we go. Here we have culture, community. So the words that come up the biggest means that several people have added the same word. So we see community, community-led, culture is big, getting bigger, tradition, uncodified rules, heritage, community-based, community-led, connections, obscure, grassroots, indigenous, informal, amazing. Community is just growing, so is culture and rules, which is amazing. Justice, life, people-focused, evolving, like that. Amazing. So afterwards, we're gonna share the end product of these word clouds as well. So you can see what you've all contributed. Okay, we're gonna go next. What do you think about when we say intangible heritage? So again, you get 3 options to add words or a short sentence, and then you can press next or send when you've added it. We can also share this later on if you feel like you want to add, but you can also add directly in the chat. Here we go. Culture, diverse worldviews, I don't know how to pronounce that word. So someone will have to help me. Shared culture, history, invisible, tradition is coming up strong, history, unquantifiable, unshakable, diverse worldviews, embodied, life, emotive, ephemeral, is that how you pronounce it? Family, I like that. Roots, connection, originally. Culture and tradition are growing bigger. Invisible, it's also quite big, which means a lot of people have said the same thing. Adaptable, not obvious. Song. Generations. Community-based, again, yes. For those of you who just joined us, we're just doing a little interactive session on what you think about. We had customary law, now intangible heritage. So if you want to add to it, you can just add in the chat if you want. If you have any other kind of ideas, both words or small sentences. So we can see that culture and tradition is coming really strong. Roots again, dialect, felt. Amazing. Okay, gonna move on. So we also wanted to ask what your main questions are for today before we start and before the presentations. You might not have any, you might have come with an open mind and just wanting to hear and then formulate your questions. But if you do have any kind of initial questions, please feel free to add them to the chat. And then we will keep them until the Q&A later and the breakout groups as well. But thank you so much for participating, and we'll share these workouts with you in the end. Over to you, David.
Excellent, thank you very much, Mia. Look forward to seeing them, that's great. So now we'll move on to the presentations. So I'll hand over to Bola for that. Just for the presentations, please remain muted throughout and possibly turn your camera off to help save bandwidth as well of our speakers. And there will be opportunity for the Q&A following the three presentations. But as the presentations are ongoing, please do add questions or comments to the chat and we'll try and capture these as we go. So over to you, Bola. Thank you.
Thank you, David. We are privileged to have three interesting presentations this morning, or well, this afternoon, depending on where you're watching us from, and perhaps evening, because I can see a few people from the South Pacific as well. So thank you for staying up at this awkward time to be with us. So we're having three presentations, like I said, this morning. We're having one presentation from South Africa, one from Namibia, and one from Ghana as well. Our presenters are persons who have got extensive experience working in the field of fisheries, particularly with communities, and they will be sharing their thoughts around customary law from the perspectives of the work they've done in the various countries that our presentations are going to be capturing. And we're starting off with our presentation from South Africa, which will be given by Mr. Wicomb, and he's with the Legal Resources Center. Is he, I'm trying to see if he's on the call, yes? Oh yeah. Yes, sorry, apologies. Yes, now I can see, I was looking through all the, yes, so welcome. And I will hand over to you first to kick us off with your presentation. Would you like to share some slides? I think we've.
Yes, I will. Thank you.
Thank you.
I can share my screen, so that's fine. And yeah, good afternoon, everyone. I have to apologize. I have tick bite fever, so I'm at about 1/4 of my strength, and this is, you might even be able to see it. So my apologies for that, but I'm going to do my best. I am sharing my screen now, which I hope you can see.
Yep, thank you.
Okay. Okay, thank you very much. Yeah, so my name is Wilmien Wicomb. I'm from the Legal Resources Centre here in South Africa, and my presentation is really about the litigation that has happened over the last decades in South Africa around fishing rights and rights tangential to it, but very particular in how fishing rights have been established as customary rights, as cultural rights, and as human rights. And I think they each have different significance and a different implication, and I'll be saying something about that. Sorry, I must just, there we go. Okay, so to start off with, as I mean, I'm sure you're very well aware, South Africa had a massive transformation and a constitution for the first time in 1993, then 1996, the final constitution. So this was a real break from our pre-constitutional order. Pre-constitutionally, customary law in South Africa, as in many, many colonial countries, or colonized countries, I should say, was seen as a separate and inferior system. It was, I don't even want to say system of law. It was not really recognized as law. It was seen as the rules governing communities amongst themselves, and it was really in a large way transformed by, certainly in South Africa, by the colonizer and later the apartheid government to become a vehicle for indirect and authoritarian rule and nothing more. So it was a way for very often traditional leaders to, at a local level, govern their communities, but those community members could not assert their rights that they had within the community. They couldn't assert that against the outside world. So, you know, the right that you had to property, for example, within your community, that wasn't a right that translated into recognized ownership outside your community. So those rules really were given no status, and they were just used to keep Black communities under control, really, and under rule in the colonial times. Now, this, of course, was not only something that happened in South Africa. The very famous judgment in re Southern Rhodesia by the Privy Council in the early 1900s, that was, of course, the common law precedent that stated that indigenous law or customary law could not give rise to property rights, because it was argued by the courts at the time, you know, there simply wasn't the level of civilization that would give rise to property rights. Now, this kind of outrageous reasoning, of course, remained law in many of our countries until it slowly started being overturned in Australia and other countries, well, late into the 20th century. In South Africa, we also incidentally had the Van Breda judgment pre-constitutionally, which gave us an understanding of how customary law, the status that it was given. And incidentally, it was about fishing rights. But Van Breda really made it clear that customary law was seen as rules that only had status if it filled a gap where there was absolutely no other law, whether statutory or common law, no other law applicable, whether there was that kind of gap, then that was a gap that customary law was allowed to fill with local rules. So that was the pre-constitutional status of customary law in South Africa. Pre-constitutionally, fishing rights in South Africa was a completely individualized system. So there was absolutely no recognition of the existence of small-scale fishing communities all along the South African coastline. When I say no recognition of those communities, I mean communities as communities, and that the rights to fish for both women and men really arose from those communal structures in many cases, and otherwise were really governed by communities. Communities fished as communities, and all sorts of activities adjacent to fishing happened within those communities, and that, of course, became an integral part to the culture of communities all along the South African coastline. None of that, was recognized at all pre-constitutionally in South Africa. The reality of it was ignored, and individual fishing rights was at the order of the day, and oftentimes members of these communities got such rights, but that only served really to undermine the communal nature of fishing rights in South Africa. So the Constitution really brought about a radical shift. And I have to say, I think at the time, in the text, no one realized how radical the shift really was. So the Constitution in section 211(3) says that the courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So no longer is customary law subject to the common law, and no longer is it even subject to statute law if that statute law does not specifically deal with customary law. So this was a radical departure from the pre-constitutional position that I had explained. But as we'll see, it took some time for the Constitutional Court in South Africa to develop what the meaning is of this constitutional recognition. And I'm not going to go into in the space of this presentation into how our Constitutional Court has developed that, but it's been really, really significant and very interesting. How over a series of cases dealing with many different aspects of customary law, whether governance or personal law or succession, how the Constitutional Court has confirmed time and again that customary law is now seen as a separate and independent source of law in South Africa. At the same time, it is part of the amalgam of South African law. And therefore, the status of customary law as law is I would think, is probably better defined now in South Africa than in many countries in the world. And this has really become a very significant tool for communities to assert their rights. Now, the other thing, of course, that the Constitution envisioned was the transformation of a deeply unequal society in South Africa. Now, for marine resources, shortly after the Constitution was passed, the idea was that that transformation would happen through not a changing of the individualized permitting system that would stay in place, but with a focus on shifting the demographics of people who have those individual permits. So really the Black empowerment of the commercial industry, that was the focus of transformation. And the minister, of course, became the custodian of marine resources. So that kind of transformation, of course, did nothing for small-scale fishing communities, and it did nothing certainly for customary fishing communities. And so many people in the room here were involved in litigation that eventually forced the minister and the state to develop a policy and eventually legislation to actually recognize small-scale fishing communities as communities. So a break from the focus only on the individual permitting system. Now, that litigation was the Kenneth George litigation, and it relied very much on the right to equality for small-scale fishing communities. I don't have the time to go into too much of it, but just to say that it led to the development of a policy recognizing small-scale fishing communities that included the principles of recognition for customary law and culture, the recognition of the tradition and the centrality of that to fishing communities, recognition of the principle of co-management, preferential access. It was really a remarkable policy, the outcome of a very long and carefully deliberated process. However, spoiler alert, none of that has materialized in implementation. Implementation has taken incredibly long and really has undermined all the principles that policy had envisioned, and I'll say something more about that as we go on. But in particular, I should say, co-management has, I would say, actively been resisted where it is really necessary in the various marine protected areas around the South African coast. So given that context, given that the policy was there, the kind of the minister was at least now forced to recognize small scale communities and give them permits, at least on paper. It just became so clear that if fishing rights cannot be asserted as rights in terms of the Bill of Rights, so as a human right, a fundamental right, that it becomes very, very difficult to make implementation real. So, and that is because when you assert fishing rights as a human right, a fundamental right in terms of the South African Constitution, and this is of course true of many of our constitutions and international law, then you shift the power away from the minister, who in her discretion can grant permits, to the power being that of the rights holder, the holder of a human right, which in this case is a fishing right. And that right can only be limited in terms of a certain very strict limitation rules. And what I put on the screen here is the South African Constitution's limitation clause. So if you can assert a human right and not just another kind of fishing right, so a fishing right normally under a fishing legislation, that's not a human right, it's simply the right to a permit. But if you can assert it as a human right, then it means that you ground that right in a fundamental right. And that's then the starting point. The starting point is no longer the minister's discretion to grant permits. And so if that's the starting point, then it is up to the minister to justify any limitation of it. And so that really, it became clear that that's really the next frontier for true protection of fishing rights and, as we'll see, cultural and heritage rights. And so that brought us to the Gongose case that finally reached the court in 2018. Now, in this case, and incidentally, I last week heard that a very similar case happened in Finland. This case, 3 fishers were arrested for trespassing and attempting to fish without a permit in a marine protected area. So these fishes, like thousands of fishes all along the South African coastline, were small scale fishes. These were customary fishes, but you know, it had never been able to get permits from the minister. So they were arrested, and the Legal Resources Centre decided to defend the 3 fishes on various grounds. So the one, which is not directly relevant, but just to give you a sense of the failure of co-management in South Africa. So these fishes are part of the Dwesa communities that much earlier in the very early 2000s had become recognized as the owner of the nature reserve where the marine protected area lies, because of a successful restitution claim. They were all forcibly removed to create that reserve. And so these fishes are part of the community that owns the Dwesa Nature Reserve. And you know, a large part of that restitution agreement, it recognized that the community could not move back into the reserve. They could not live there as they had before they were forcibly removed, but they were supposed to be owners and co-managers of the reserve. Now, this incident happened 11 years later. These fishes were arrested for trespassing on their own land in the reserve. That is the extent of the failure of co-management, certainly in that reserve, and sadly, that is the case in many marine protected areas around our coastline. So the trespassing charge was very easily dismissed, because of course you can't trespass on land that you yourself own. But when it came to the charge of attempting to fish, our argument was that these communities were not, or these fishers were not acting unlawfully when they fished. They may not have had permits, so they were not acting lawfully in terms of the statute law, in terms of the law that made the minister the custodian of the resources, but they were acting lawfully in terms of their customary law. And in order to make that argument, we had to, at the trial, lead evidence to prove that this community had a customary system that was not only about fishing, it was about many things. It was about the governance of the community, the rituals of the community, the personal law, the landed property of the community. But also within that customary system, many people were recognized as the fishers of the community with rights to the local marine resource. And we were able to prove factually that that system existed and that those fishing rights were part of the system. So, of course, the litigation went on for many years, 8 years, but eventually in 2018, the Supreme Court of Appeal then recognized and found that indeed this community has a customary system. That customary system gives rise to customary fishing rights, and those rights rendered the actions of these fishers lawful. And you will remember that I said that our constitution says that customary law in South Africa is only subject to legislation that specifically deals with it. And because the marine legislation never bothered to recognize customary law or customary rights, the court said you didn't deal with customary law in your statute, and therefore it does not apply to the customary rights of this community, and they were acting lawfully when they fished in the reserve. We also argued for customary rights as part of the right to culture, an expression of the right to culture of the community. And that, of course, triggered the protection of those rights, those fishing rights, as fundamental rights to culture. And as I explained before, that is a very important additional trigger of protection for these communities. Now, I'm not far from done. We now get to how these gains that were made in litigation around Dwesa Kwebe and the protection of the fishing rights have now very explicitly become the basis for the protection of these communities' cultural rights, heritage rights, and certainly their right to, at a minimum, consultation. So in 2021, at the end of 2021, last year, we suddenly saw an onslaught of exploration permits granted or triggered by various companies along the South African coastline as, South Africa or Africa becomes the new frontier for oil and gas exploration. So first, Shell announced that they would be starting to implement an exploration permit that they had actually had since 2013 along the wild coast of South Africa. And to do this, of course, they would perform seismic surveys, which is the method they use in order to ascertain whether there's oil and gas reserves. Now, the area that they were going to target, we realized, was right in front of the Dwesa Kwebe community, and a little bit south of other communities that also have customary rights, certainly to the land and the marine resources. But also, the communities told us the ocean is not only central to their livelihoods, but it is central to their culture, their spiritual being. The ancestors, they told us, live in the ocean. And therefore, the idea of a seismic survey, which is, massive air guns blasting continuously into the ocean floor, that the idea of that was incredibly offensive to their beliefs and certainly to their right to culture. So these communities, and the Dwesa Kwebe community was on the back of having had their customary rights recognized. They approached the court urgently at the end of last year, seeking an interdict to stop Shell from proceeding with the seismic survey, because Shell had not consulted them, had not spoken to them at all. So what Shell did do, and I think this was quite critical, on the one hand, they did consult with commercial and recreational fishers. So they knew that it was important to consult with the fishing industry. They just ignored the small scale fishing communities. The second thing that they did was, when it came to heritage and cultural impact, is they visited 4 monarchs in the province of the Eastern Cape. So 4 kings. Well, actually, one is a queen or senior traditional leaders in the province. And Shell claimed that they had consulted with these kings and a queen on behalf of all their subjects across the entire province, and that was sufficient consultation. Now, of course, the communities took issue with that entirely and said, that's not, we cannot be reduced to be the subjects of a monarch and have no voice of our own. You did nothing to come to us and understand what the impact will be on our fishing rights and on our cultural and heritage rights. And for that reason, for your lack of consultation, you cannot go ahead. So quite remarkably, the communities were successful and Shell was stopped from conducting the survey. The case is ongoing, though. The communities have also argued that Shell should have had an environmental authorization, and that case comes up later this month. But I mention it because the communities go further in arguing in this bigger case now that, yes, you should have consulted us, But we also have a self-standing right to our customary law. We've proven that we have customary systems. The previous courts have recognized that. And those customary systems are protected by the right to culture. They are therefore fundamental rights. And therefore, you cannot interfere with our fundamental rights without showing that you are doing so in the most sensitive way possible, and only as far as is necessary. So it's not only about consultation, it is also about directly protecting our right to culture, which includes the customary right to fish. But the communities argue also include the duty to protect the environment, which is part of the customary law of these communities. Now, we don't know to what extent the court will accept those arguments, but they are going to be made, and it will be interesting to see what happens. Just very briefly, the same thing happened then on the west coast of South Africa. In January this year, fishing communities on the west coast heard that an Australian company was planning to do seismic surveys along the entire west coast of South Africa. Now, the west coast of South Africa is entirely known for the small-scale fishing communities all along its coast. So for perhaps complicated reasons, it's not clear that they can necessarily assert customary rights on the west coast of South Africa. That it's a different tradition and history, but they can certainly, and they did certainly, assert the right to culture, given that snook, the species that's not only central to the right to food of these communities, but to the culture of West Coast communities. And that species stood to be impacted. The communities went to court, challenged Searcher for, again, not consulting with them. And again, they were successful in the interdict, and the company left and in fact abandoned the permit that they were granted by the minister entirely. So the arguments were very successful. Now, all of that seems to be very good news, but the bad news, of course, is that new players, new oil companies are already gearing up to tick new boxes that they've now learned should be ticked. So consultation, if it's a tick the box exercise, if it is not informed by substance, by the protection of a fundamental right, then it is weak, and it gets us very little. What we saw with the Gongosi judgment is, even when we have the importance, even if we have the recognition of customary law, the state can do nothing about it other than ticking boxes. If there's not this recognition that we are looking at a paradigm shift, we can't just change the rules from individual permits to community permits, or from a certain form of conservation to co-management, without recognizing that that requires an entire paradigm shift, and that remains lacking. And it's something that can't be fixed by litigation. Co-management, therefore, remains a myth in South Africa, and we see our government storming ahead with an ocean economy master plan currently still leaving fishers behind, despite all these important court victories. So I'm just going to leave you with the words of one of our fisher leaders, Christian Adams, in a meeting with the minister about the plans of the South African government to mine and otherwise extract the ocean, the blue economy. And without speaking to the fishers, and Christian said, where will we end up? Are we going to be murals for people to look at and to say, there was once a thriving small-scale fishing sector, but it's gone. Thank you.
Thank you very much for that excellent presentation, looking at how customary law has been used in the South African context to guarantee the rights of fishing communities. There have been a number of questions coming in already asking about various components of it. Please keep your questions coming in. You can put them in the chat and we will put the questions to the presenter at the end of all of the presentations. So we want to have all of the presentations first before we then come back to specific questions for each of the speakers. At the moment, we are going over to Ghana to hear a presentation from our speaker from Ghana, Mr. Yes, is your video on? Can you switch on your video? Yes. Yes, Mr. Balertey. He's with Mpoano, which is a civil society organization based in Ghana, and they work with fisher communities on a range of interventions, and he will be speaking to us about those interventions, particularly around the question of customary law and protecting the fishing rights of communities in Ghana. Mr. Gormey, are you there?
Yeah. Thank you very much. Bola, I think I'll pronounce it very well. Yeah. Okay. I think it will be good for me to share the presentation. So let's take a few minutes to do that.
We've given permission for you to share if you try to.
Desktop. Please, can you see?
Yes, we can see it, but if you can put it in presentation mode, at the moment we can see it in a draft format. So if you kind of click to make it presentation mode. You go to slideshow. If you go to slideshow, then it lets you. Yes, that should do it. The first one, slideshow. Yeah, that's it. Yes, excellent.
Okay. Okay, the title is the Customary Law Eternal Rights for Fishers in Ghana, and talking about the Mpoano experience. Mpoano, as Bola mentioned, is a civil society organization, and the word Mpoano in English simply means our coast, which means that for some time now we have been working with coastal communities in terms of public education, awareness creation on their rights, vis-a-vis customary and contemporary laws in Ghana. So, by way of introduction, I'll say that in Ghana, and maybe in the literature, customary law constitutes some written rules and regulations established through many years of observances by traditional societies. And in Ghana, because of because we have many tribal groups and homelands, we have many of these customary laws and rules and regulations, which are location specific. And one thing about these norms or rules is that they are based on culture of the people and embedded in religious beliefs of the people concerned. One thing that is common with this law is that they do not deal with individuals. The focus on the law is on the community. So all rights granted under customary law are not for individuals, they are for the community. This is because these communities are there to promote harmony, not to encourage dispute, to bring about division and so forth. That is one thing. Now, when it comes to the conservation of natural resources, you realize that customary laws relate to the natural resources and they form the belief system of our people. Because in Africa, whether in Nigeria or in Ghana, some of these natural resources and some, in most cases, we consider them to be the abode of the deities or the gods, especially in African religious, traditional religious thought. Next slide. Yeah. Now, in all societies, before, I mean, these are way back in time, and most of these things, because they are not written, they are passed from generation to generation. Those of us who grew in many communities realized we were told oral traditions and the observances are passed on to us. And the enforcement system, of course, is led by the community through their chiefs and the priests. And the offenders know the consequences should you violate any of these laws. In Ghana and many countries, customary law provides the basis for new laws in Ghana, in many countries. And Ghana, like many countries, accepts customary law in areas law. So the provision is that these customary laws must be consistent with the provisions of the national constitution. So if you look at some of the rulings, it is clear that where it comes to culture, they make references to the culture and see whether that practice are consistent with the main document, the supreme law of the land. And as I already said, in almost all the places, especially in forestry and in fisheries and the river systems, this is the basis, the framework for the conservation of natural resources is based on these religious beliefs or the laws or the norms. And if you look at, especially in forestry, most of the forest reserve, where we see areas which are fairly intact, you realize there are sacred groves and other areas where animals like monkeys and all those things are there. Some of the areas by law, of course, burial grounds and all those things, where you see the whole forest devastated, but you see a patch of forest which is fairly intact. This is the basis on which our traditional customary laws and observances are practiced. Now, in terms of tenure rights, as I earlier indicated, exist under customary law in many societies. I mean, the right to use community natural resources are guaranteed, provided a person is a member of that society. And some of these, though the rights, they go with what? Regulations, which are tradition. And from observations, you realize that customary law in Ghana, the Ghanaian context, there's a level of fairness in allocation of resources because the resources are owned by the community, and therefore under those circumstances, should somebody be denied of his right to use land or the sea? And but as the country develops, like many developing countries, securing these rights is becoming an issue. And this is the area where Mpoano, as an organization, has been working for some time under its fisheries and governance program. Now, the first thing that we have done, and we still do, is to look at how best to secure, in terms of fisheries, how best to secure landing sites. This because in Ghana, if you fish and you cannot land at the beach, then you are not a fisherman. So the landing sites become very important for the fishing industry, the small scale fishers. And if you deny the fishermen the landing rights and these landing sites, then you as well throw them out and say that nobody should go to sea, because that is what they do. And in traditional terms, they have their governance regimes to make sure that these landing sites are managed, the leadership, the traditional system, which is independent of even the local chief. The landing sites have their chief fisher folks with their rules governing the behavior of fishermen. It had been there before, even during colonial time, before colonial time, and even after the colonial era. And government since the independence have accepted this. Though there is no legislation to say that all landing sites by law are recognized, it is clear through traditional or customary system and beliefs and practices that these landing sites are there. And government, of course, through the Ministry of Fisheries and Aquaculture Development, recognizes the existence of these leaders and resources coming from government, like subsidized fuel nets. These are shared to fisher folks on the landing side basis. But over the past 30, 25, you see that some landing beaches are going away because the landowners have started giving out parcels of these landing beaches to developers, especially along the coast. You see hotels and other recreational facilities being developed. This is displacing some of them, the fishers. Now, because they lack documentation, of course, the customary land, they just verbally give out the land, and somebody says, settle on this land to do your fishing. No documentation. So over time, when they give out, the landowners or the customary owners of the land give out these things to developers, the fisher folks are not able to go to court to say, we have this document and this and that, and the court cannot accept this argument that we have been here, therefore you own it. And we have seen clashes with these developers, and some of these have been reported to the police, and but in sometimes the cases are not resolved. Either you move or relocate to another site, or there is nothing you can do. Now, to secure this landing site, HM, that's HM, I mean, in Mpoano, we started piloting some arrangements to secure this site as part of the VGGT process. So the pilot took place in the central region of the Republic of Ghana, and also a location in the Greater Accra region. And I will show slides on an example of what we have done to secure at least one of those beaches, the processes. this was done under a project we call FDN. That is the progress of the fishing industry. That is the local term we say Fare Human Cordova. This one is like sustaining the fishing industry. And the project's contribution to securing tenure rights. The first step in securing tenure rights of the fisher folk was to secure access to coastline space for fisheries-related activities, including berthing of canoes, mending of nets, fish processing, and marketing. The other example has been to carry out extensive mapping of 118 landing sites along the coast of the central region and a place called Adan in the greater Accra region of Ghana and another small community in the Volta region. So ostensibly in 3 regions, this mapping, we have about 400 landing sites. And so we were able to map. We did this mapping. Prior to that, there was no map of this landing site. So we piloted the mapping of this landing site as the first step towards securing their rights. The second step was that the project will also demonstrate how land ownership and documentation processes can be used to, as it were, strengthen the tenure rights of fishing community to their landing site. You know, one of the responses was also to bring together these clam harvesters to discuss the issues and also with the relevant stakeholders. Here you show a map of one of the villages. This is a small village on the map. Hello, I hope you can see it. And that is the small village there. And so we have to map this coastline, line for them to see that this is the area where those small canoes here and there, they come and land. These are the villages, the toll lines. So we have a case study, a short list of landing sites produced based on the will of the traditional authorities and fisherfolk. In Ghana, we have 2 systems at the coast. You have the traditional chief, who is the overlord, and then you have the chief fisherman at the particular landing base who manages the affairs of the fisher folks in that particular location. And one of these locations, what we call the British Commander, was selected as a case study under the project. The problem was, first of all, we have the potential threats arising from planned works under a sea defense and an erosion project. Then you also have what is stool land, and then also look at the history of the area. First thing was to acquire the land from the stool. In Ghana, traditionally, land belongs to chiefs. In some areas, too, you have families and the individual. But where we started the work, the land belonged to a stool and then some families. So we have to approach these people for their consent, whether they would like that land which belongs to the stool or the family to be mapped and registered as a site specifically given out to fisher folks. So we identify the land interest and the owner, the site of interest in consultation with town and country planning for its intended purpose and usage, and then you obtain a cadastral. Then the search, you confirm ownership of the land. Then an indenture is drafted, and then 4 copies of the final indenture and a minimum of 10 copies of the cadastral plan are then signed by the executive and their witnesses. The documents are taken to court for endorsement. The next stage is the deed or the title registry. Now the process, I just summed it up: mapping of landing sites, community engagement, cadastral service, and then the indenture. These are example members of the community who engage the leaders, their signatures to confirm that yes, they consulted us, we signed, and then we gave out this land lease agreement to the fisher folk. Then there is the indenture preparation. They have to come up with the oath that they are giving this land endorsed by the land department. Then when the document was registered, it was finally presented. Now, the non-black person, I would say the white, non-black person there was from the European EU Commission, just a witness that under the project supported by the EU, under this fisheries governance project, is that the traditional leaders have been presented with a document to show that that particular landing site is now documented, and they have the property, they have the right to protect it, and they can go to court and defend it and win. Unlike other areas where no document exists and they can be thrown out of that place. Now, there is one aspect of our work. We have done the landscape, that is the beaches. One area where we also try to educate people in terms of their customary rights, community rights, and then the channel was that we approach it from the background that the ocean is governed from the coast and not from the ocean, meaning that even seaward, if you have to do something, you need to start from land. And so while the government, of course, they have identified this inshore exclusive zone for small-scale fishers, many of these people are not aware. And so they've been catching, and sometimes when their nets or gear or canoes are destroyed by the trawlers, compensation, evidence to provide for compensation had not been easy. So the main objective of the seascape was that, first of all, we produced maps of the landing, the inshore exclusive fishing zones to help them do their work, so that when they go out to sea, they know that when we say 6 nautical miles or 10 nautical miles, this is the limitation, and you do not cross beyond. But that when the trawlers, sometimes the trawlers come within and destroy. So when the trawlers come, you know, you take pictures of some of this, you present to the Fisheries Commission to assist in conflict resolution and also compensation. So we have used this tool, which is also in the pilot phase, to demonstrate that, and it has a system that has been used extensively to even educate the fishers on responsible fishing practices. This is an example of the IEZ, which was developed, and the areas where we mapped, they were presented, the fishermen were presented with this map to know the areas where they can go and fish, the limitations and the responsibilities and their rights as far as this is concerned. In fact, I must state here that the IEZ is recognized by government. So, because unlike South Africa and other countries, our fishery, marine fishery in Ghana, is open access. And therefore, because of open access, nobody can be restricted from going out to sea. That's one clear difference about it. The right to go to sea, customary guaranteed, and in terms of current law, they are guaranteed to go out and see. But of course, this open access regime has also got its own challenges in terms of overcapacity, overfishing, etc., leading to dwindling fish stocks, especially the small pelagic. And this has been the focus of Mpoano over the years. So this is where we are so far. But the next step, of course, is to see how we collaborate with state institutions to educate people in an attempt to identify areas for potential marine protected areas. Thank you for your attention.
On mute. Thank you very much for that presentation, looking at securing tenure rights of small-scale fishers in Ghana. So what we're going to do now is try to put some of the questions that have been coming in the chat to our presenters. Please keep them coming. If there are any more questions, if you pop them into the chat as the discussions are going on, and we hope to have an engaging session where speakers, panelists will be able to attempt to answer some of the very interesting questions which have arisen from their presentation. David, do you want to take over and go through some of the questions, please?
Yeah, of course. Thank you, Paul, and thank you for two fantastic presentations as well. We can either read out the questions that have come in via the chat, kind of just reading them out, or we can ask speakers questioners to ask them live. So I'll give the opportunity to do that too. If you do want to ask a question live, if you use the reaction button down the bottom of Zoom and just click raise hand, I'll keep an eye on that as well if you've got any questions. Just now all that come up with the discussion. I'll just ask the first question that came in. This was from James Bell. James, do you want to ask this live? You can if you want.
Yeah, I can do. Thanks, David. So it's going to just to say, in a lot of areas, we really see that there's a kind of very urgent need for drastically improved management, and the Ghana's small pelagic fishery is a kind of prime example of that. I mean, we've heard that the sort of participation process for communities is very long, and not rightfully so. But how do you kind of reconcile those two different timescales of needing to make big changes fast, but also including the right people in those decisions? And
thanks, James. Wilmien or Balertey, would you like to take that question?
Yeah. You see, in Ghana, we have I think four coastal regions, and so consultation processes are very, very long, elaborated, time consuming, very difficult and expensive. And so we normally begin with the process of piloting in areas where the fishing is very dominant, especially if you go to central region of Ghana. In fact, that is the hot bed. I mean, I don't know, is it hot seat or what bed for artisanal fishing? In fact, most of the things we do in coastal Ghana fishing are based on the traditions in this particular region because of the fish and the rich. I can't call it rich anymore. We was near collapse. Yes, collapse of pelagic fish. Yes, and that is why the focus has been on that one, to engage them and to believe that they have a very large number of fisheries. In fact, to the extent that they even go to other countries like La Côte d'Ivoire, Gambia, Liberia to fish. Some other go eastwards to Benin, Republic of Benin, Cameroon. Kenyan fishermen are all over the place. to the change. But the most difficult and long process is to address the issue of open access. In fact, if you try to restrict open access, you may also be violating customary law. It is a fact. Any attempt to legislate a piece of legislation that limits or reduces the scale of the open access regime in Ghana, I'm not a prophet of doom, but I think it will lead to resistance. But the open access regime is also a very dangerous to fisheries management, because as we speak, no legislation governing the size of a canoe, and you come to Ghana, you see a canoe, and you see that in fact this is canoe, in some countries that thing is classified as a boat. So it is an over capacity, and of course, government is trying to address this, but it is through consultative process, so that the emphasis is on voluntary compliance and not to force people, because the issue of human rights and then the right, and these rights granted by customary law is something, and this is the issue where the clash between the modern fisheries management rules, law, and customary law or rights. The question now for all of us to answer is, how do we address this? Of course, the history of South Africa we know, but an attempt by the colonial regime to regulate land ownership, control land ownership, was resisted as far back to 1900 in Ghana. So we do not have the kind of experience you have in Namibia, South Africa, and I think some countries in East Africa. Our system is different. I think Nigeria is also open access. I think it is only in Liberia where some level of restrictions are there, but in English West Africa, it is something. So let's all think maybe this will be the way in which we try to look at how best to bring together a modern law and then the customary law to address fisheries management in that.
Excellent, thank you, Balertey. Wilmien, would you like to come in?
Yeah, just one thing that I want to add, and indeed, I think the context is very different in South Africa. So you know, where you would want co-management, or there's currently incredibly fierce management. So you know, our conservation management in South Africa, specifically around MBAs, are pretty militarized, and you know, very often also dealing with rhino poaching and things like that. And when you're dealing with rhino poaching, then that is kind of a blanket excuse, it seems, to enforce with a hammer any other kind of regulation. So what you're seeing at the moment is that communities around MPAs, including Dwesa, but certainly others, northern KZN, Isimangaliso, as you see fishers being shot and killed for being mistaken for being poachers or whatever. But there's so little care by conservation agencies as to who they're encountering and what the rights of these communities are, that you know, that they're facing unbelievable harassment. And so it's kind of, despite this incredibly militarized enforcement, that communities continue to seek out the marine resource, because it's their life. So in that context, but I think it's kind of a more general statement. I mean, I think we must also, you know, we always think about communities that require empowerment, and you know, the consultation with communities. I think that we're completely missing the incredible amount of training and change that is required within the authorities, the governance, the conservation authorities or the relevant management authorities. I mean, so the point is, what we've seen is that, by simply suddenly telling them that from now onwards you are going to co-manage this reserve, you are now going to take the community seriously as a partner, you are going to recognize their rights. I mean, that's not led to better engagement between authorities and community, but worse, because I think the authorities don't know how to engage with communities. They don't know how to recognize their rights. They're fearful of these communities who now have rights, and as a result have become far more aggressive and hard on communities. I mean, it's unthinkable that the Dwesa community owns the nature reserve, and yet they're held away at gunpoint by rangers from their own land. And I think it's a function of the fact that we've never thought that the authorities themselves need to be transformed. You can't just change the rules without transforming the people applying those rules, and I think that requires a lot more of our attention.
Excellent, thank you very much. Do keep your questions coming in, and if you do want to ask a question live, please just put up your hand using the reaction button. I can keep going through the questions we've had in the chat so far. This question kind of relates to what we've just been discussing, but I think we can possibly discuss this more, and it comes from Balertey Tawaki, who I think has had to leave. Has had to leave. But he had asked, why has it taken so long to be implemented? I think this was referring to some of the decisions that you were just referring to, Wilmien. But I guess the question is, why does it take so long for these to be implemented? Is it that concern, that almost, as you say, sort of fear of granting these rights to communities, despite the decision being made? There's a sort of long-term delay and long-term questions about how this should actually be implemented.
Well, when it comes to the South African experience, I mean, the implementation is it's a combination of things. So I think that is certainly one of the issues, but it's also that there are unbelievably few resources granted to the recognition of small-scale communities. I mean, the Directorate of Small-Scale Fisheries, others in the room can confirm it is coming as a handful of people. It's supposed to be rolling out small-scale fishing rights across the country. So that's it's just a function of it not being seen as important. Then around Gongose, we're incredibly frustrated by the fact that the state does not understand how to properly recognize customary systems as they are, how to use that as a starting point, right? Let's go down, let's understand what is happening on the ground. That's our starting point. And from there we regulate and decide on co-management. Rather with their limited resources and incredibly limited knowledge, they decide, let's just work out a one-size-fits-all model right at the top and go and impose it on all the communities at the bottom. That's all we can manage. And so, that exactly as my colleague has said, that that's just caused unbelievable resistance from communities, and also, it's just ruined the rollout of the implementation. So many reasons, but I mean, fundamentally, to me, it's about still just not a lack of recognition, a lack of and when I say recognition, a lack of recognition of how important these communities are, a lack of understanding these are fundamental rights, and just it's a little side project, and this is not the kind of sector that you can deal with in that way.
Thank you, Wilmien. Balertey, did you have any thoughts about the sort of how long it takes to implement the sort of solutions that you've been working towards with regards to the mapping process? So when you are undertaking this mapping process and you take it to government officials and those in charge of fisheries policies, how do they respond to this, and the sort of how do they begin to start implementing, or do they begin to start implementing the recommendations that you're coming with?
Okay, thanks, David. You see, in Ghana, things work unfortunately slowly because the government of Ghana doesn't own land. It acquires lands by using what we call the principle of sovereign eminence, that the right to acquire land for specific purposes. So it takes land from, I can't take, acquired from chief, that is the so-called landowners, and then they'll pay compensation. This has been the arrangement since colonial time. So when government acquires land, it becomes state land. So when it comes to most of the coastal areas, there are even regulations, but then it is up to these chiefs to accept the regulations or not, because government has not yet acquired the coastal land for it to determine where to go. So before, and by the time the colonial masters were here, the people settled and they were fishing. Some 150 years, some 120 years. And at that time, population was very small. And so they were settling uncontrolled, they were coming until the modern times when there appears to be land hunger, that in quote, along the coast because of new development, the tourism facilities and industrialization came in. And currently we have the issue of the petroleum industry, which is offshore, and they are acquiring land for new projects. So the conflicts are beginning to emerge. That is why we came in under the VGGT, the voluntary guidance on field right, to begin with, so that areas which are remote, so to speak, and may not be engulfed by this fast development should be able to secure their rights through what we started. Because in actual fact, when we started, all of them did not even know the size of their landing sites. They've been there doing that until when we did the mapping, though it had not been registered, some use the map and they now recognize the size of the landing site. And they are even using this to negotiate with the chiefs, the landowners. First, you must negotiate with the landowners before you begin the process of documentation. And of course, the conflict with modern business is that you have to even talk to the land, town, and country planning authorities. Land use, now we call the land use something authority of Ghana. You go there, and then the land commission, because whatever you do under the traditional system must be endorsed by the modern land registration system, as you remain in the oral tradition for that. And that is where it may take many, many years. Of course, another level of advocacy is to call on government to just pass a law to recognize existing landing sites. On the basis of that, then it will be, it's like government has acquired every landing site now for the purposes of fishing. That will make the system easier, but it is also not easy for government to accept this. It will take some time, but with consistent advocacy, I think we shall see light at the end of a very long darkness. Thank you.
Thank you, Balertey. Excellent. Thank you so much. Let me just go on to our next question here. And as I say, please do raise your hand if you'd like to ask a question or continue to post in the chat. Meryl, would you like to ask your question live, or would you prefer if I just read it out?
Hi, thanks.
Hi, Meryl.
Thanks to both the speakers for really interesting presentations. Yeah, I had a question for Wilmien, and thanks for that excellent presentation, Wilmien. I mean, we've got these constitutional provisions, we've had recent judgments, victories, and yet the government is still very reluctant to recognize customary fishing rights. And, I'm thinking even of, say, the Mangabane judgment, where the traditional fishers were then allowed to fish in a particular zone in the marine protected area, but they're still being chased away. We don't have co-management, set up in these various areas. And I'm wondering, I think you've given some answers already, actually, in responses to the other questions, but, what actions, what are the next steps that we need to take to ensure that these judgments and the constitutional provisions are in fact enforced? I mean, you mentioned, that basically people don't know how to interpret the Gongosi judgment. You mentioned, that we need more training. We've got to put more emphasis and more resources to training of officials to understand what these customary constitutional provisions mean and what the judgments mean. But, I'm just thinking in terms of actually NGOs, communities following up on judgments where they are not being enforced. I mean, is it kind of more legal action, or how do we ensure that those are enforced?
So, I mean, that's a very difficult question, Mil. I guess it's, I mean, I would like to say it's not more legal action, but I guess it is a little bit of a combination of it. But I think legal action should be, I think what we keep learning is that legal action really has its limits in providing the answers that we want. And so what does that mean? I mean, the one thing I'm worried about, and is the extent to which there's grown such a tremendous kind of animosity between the state and everyone else, whether it's civil society and the small scale fishers and so on. And I mean, I guess it's expressed in the fact that we can only really now talk if we're in court. And it seems to me that's incredibly damaging, and I don't know how one gets past it, but it seems to me there is real value in trying to see whether one can get past it in some way, because I don't, you don't, we always say you can never win an argument through correspondence as lawyers, which is true. And I feel like that's where we are in trying to solve these intractable problems in South Africa, because we've become two parties at opposite ends of a court, a tennis court, and not willing no one's willing to give an inch, in a sense. And I just, that really concerns me. But how to solve that, I don't know. But it seems to me that we're not trying. We are all now in fighting mode for good reason. But I don't know if that's going to get us where we want to go. But I'm very feverish, so don't take anything seriously that I'm saying.
It does feel that one really needs to think, there needs to be like a brainstorming around the strategies to almost get out of this very polarized situation, that, as you say, the only way you can begin to resolve issues is to go to court. That seems to be the only forum. And one's got to think about how one can be more kind of productive, I suppose, in moving these things forward and getting recognition of these rights that are recognized in these court cases.
Excellent, thank you very much. Balertey, I see that your hand's up. Would you like to come in on that?
Thank you very much. In fact, what Mel, or I think, yes, I hope I pronounce the that it is a very complex problem, not only in South Africa. It's a general problem across most countries on the continent of Africa. Judgments from the highest court of the land, enforcing these judgments are not easy. I don't know whether it is the weakness on the part of central government or the inability of local communities and also civil society organizations to always persist. Because if they don't persist, then judgments will be kept in their drawer and nobody enforces them. And the South African experience is giving us new insights into complex issues that will arise in the years to come, especially in areas like Ghana. In fact, in Nigeria, we have some areas where oil exploitation, pollution of marine and maybe other water body system. And the Nigerian government, to the best of my knowledge, have not been able to implement or enforce some of these court decisions. And in Ghana too, as we begin the planning to get the marine protected areas and as offshore oil and gas exploration restricting access of artisanal fishers to some of the offshore oil installations, I think these are emerging issues where, for example, if a court rules in Ghana today that the siting or installation of oil and gas production system offshore is a violation of this, I don't see how the government of Ghana and the immediate future enforce that law. This is what I call a very wicked problem. Thank you.
Excellent. Thank you, Balertey. Excellent. Carsten, I see that your hand's up. I'll come to you next.
Thanks a lot, David, and thanks for the presentations and the interesting conversation around the presentations as well. I work for the Transnational Institute based in the Netherlands. I've worked with several of you from South Africa for a number of years, so hello everyone, and also hello all of you I do not know and meet for the first time. I wanted to follow up on something that I think relates to strategies, what tactics, what can actually be applied. And for me, it's clear that litigation is one important strategy in a political struggle to secure the rights of small-scale fishers. But I do think there's more to say about, there was one comment in the box by Carmen, and she referred to what is the current vision of development along the coastlines. And to me, this raises a question of placing small-scale fisheries in a much broader picture. I know in Ghana, if I'm not mistaken, I mean, correct me if I'm wrong, that there's also a process of developing a marine spatial plane. Now we know marine spatial planning is about carving up the ocean and allocating the ocean to basically those with most political power and influence. So that is often big corporations, transnational corporations. When you spoke about oil and gas, mining, there's also port development. And I mean, you also spoke a lot about marine protected areas and the threats that these poses to small-scale fishing communities. So I'm curious to hear more about, I mean, in particular in Ghana, because I don't know much about what's happening in Ghana. What are the plans of the government? What's the priorities? For me, looking many places around the world, not just Ghana and South Africa, small-scale fishing is not a priority. It doesn't contribute significantly in economic terms. It contributes in all these other ways, obviously. But it is simply not a priority of governments who pursue profits and want big development projects. So I think small-scale fisheries, when we talk about it, has to be located in that context. And I think litigation is one important strategy, but there's more to it. So I will stop here, and then I hope that you can share your thoughts on some of these reflections. Thanks.
Excellent, thank you, Carsten. Yes, Balertey, please go ahead.
Okay, it is true that Ghana is preparing to start the marine spatial planning process. Consultations meetings being held, and idea of MPAs are being, but see, in the whole thing is being done in the context of the emerging oil and gas industry. And oil is the big elephant in the room. The moment that elephant enters, everything changes. We are used to this. Ghana can come out with the most brilliant marine spatial plan, the most brilliant, even a Nobel-winning plan. But before God and man, the plan will not be implemented. It will never be implemented. Immediately, oil enters or any important mineral is discovered somewhere on the seabed. They will find a way. Another problem that I foresee is the powerlessness and the disorganization of the small-scale fishery sector. Of course, in Ghana, the situation is a bit different in that the small-scale fishery sector, the people there, about 3 million people or so engaged in it, constitutes a political constituency, which within the context of the new democratic experiment have changed governments. In fact, they have been changing governments. If they are annoyed with you, you are likely to lose the election. But some of them to exercise this power, they don't know their strength. It is only election time that they make noise about change government. Then the new government comes and then does the same thing. But they have the potential to influence decisions, which of course they have to be mobilized. And the mobilization will come from some change agents who go around and it sees that these people understand the issues, understand what to do, and make sure that the people know what they gain from taking certain actions. On the basis of that, we can solve, because they will tell you they have consulted the people before you realize the plan will be out. And it will be accepted. The implementation will not be anything to write home about. Once we have the oil and gas installations already out there. Thank you.
Excellent. Thank you very much, Balertey. I think now we're kind of reaching the sort of end of the Q&A, although there's still lots of questions that could be asked that are in the chat, and hopefully our speakers can either answer them in the chat or answer them later on after the fact. But what we're going to do just now is move into a break for about, let's say, 10 minutes or so. But before we do that, after the break, we're going to go into using Mural to just facilitate a broader discussion amongst ourselves rather than use breakouts, because there's about 23 of us still on the call. I think actually we're better off just staying in the main room and we can all work through the mural and add to it and discuss as issues are coming up, rather than going into much smaller breakout groups, if that sounds okay. Mia, do you want to introduce the mural? We posted it there.
Yes, I'll do that briefly. So I don't know if people have used Mural before, and I hope you can access it simply. But I'm just going to share my screen quickly to just show you what we're looking at. So when you come into the mural, you should come to it here, where you can see it's a big board where you can add text and kind of like post-it notes. If you zoom in, you can come closer in and you can read the text that David has prepared for us, and some of the questions that we've been talking about, which we'll introduce when we come back from the break. But just briefly, that if you want to put any more questions or comments, you can double click and say, great presentation, for example. You can also add your name if you want to, but you can also keep it completely anonymous. If you do want to add a sticky note, because they're all taken, you can go on, here, press there, and you can move it wherever you want to put it. There we go. And whatever color you want to use. So you can play around with it a bit during the break, and then we come back to this when we come back after a few minutes. David, you want to tell us about time quickly?
Oh, sorry, I was on mute. Yeah, thank you very much. So yeah, please click into the mural board and start adding comments and start adding questions if you want there during the break. I think we'll take a break for 10 minutes, just to get a comfort break, get coffee, tea, or anything else. So if we come back here in 10 minutes at 11:55 UTC, I believe was what it will be. But yeah, 10 minutes from now, we'll just stay in this group and we'll start to delve into a sort of broader discussion as well. But before we do that, I just want to say thank you very much again to Wilmien, Wicomb and Balertey, Gormey for their wonderful presentations. So please join me and give them a round of applause, virtually and digitally, whichever way you want.